Good morning. Welcome to our debate on the recent decision in URS Corporation and BDW Trading Limited, in which the Court of Appeal considered aspects of the Building Safety Act for the first time. My name is Kerry Bretherton KC, and I will be chairing today's session. I'm a SILT specialising in property development and associated commercial transactions, with a particular interest in the BSA and fire safety, which forms a substantial part of my work. I've appeared in many cases in the Court of Appeal and Supreme Court, and was nominated for Property Litigation Silk of the Year last year by Legal 500. Developers, principal contractors and building owners have been waiting for clarity regarding a number of aspects of the Building Safety Act, and this decision provides clarity on certain aspects of the legislation. We'll be discussing four particular aspects of the judgment. I propose to open setting out some key facts, and then we'll speak to David Sawtell regarding the scope of the URS duty of care in this case, then turn to David Hopkins to assist with regard to duties under the Defective Premises Act. I will then speak about the Contribution Act, and finally Hannah Fry will give her insights on retrospectivity. Before I turn to the facts, I just want to mention that time doesn't really allow for questions, and therefore we propose to put our email addresses up on screen at the end of the webinar so that you can contact us for questions by email, and we will follow up with those. Furthermore, I would invite you to go to our website in any event, because we've written an article on this case, which is published on the website and freely available to everyone. To turn to the facts of this case, this was a case in which BDW Trading Limited, the developer, attempted to bring a claim of negligence against the structural engineer, which was allegedly responsible for a number of defects in design of buildings, URS. It had instructed the appellant to undertake structural design on two developments, one based in the Isle of Dogs and one in Leicester. The one in the Isle of Dogs comprised of 5 tower blocks ranging from 10 to 18 stories high, and practical completion of that development occurred in around March 2007 to February 2008, and then the apartments were sold by individual contracts of sale. Although the developer had a 200-year lease, their interest in that head lease was transferred in December 2008. The Leicester development was 7 towers, each 6 stories high, with 32 apartments. Practical completion of those blocks occurred between February 2005 and October 2012, and the individual departments were then sold to purchasers on long leases, and BWS's freehold interests were transferred on later dates. Following Grenfell, the developer undertook a investigation and review of its stock and discovered significant defects in the structural design of 2 tower blocks, although no physical damage had occurred. And so it's commenced negligence proceedings in March 2020 against the designer, being out of time to bring claims in contract. At the preliminary hearing, the judge held that the URS duty of care related to the risk of economic loss that would be caused by construction of the buildings using negligent design, and the cause of action accrued no later than date of practical completion. And then after the preliminary issues hearing, the Building Safety Act came into force, and there was permission to amend to take advantage of increased limitation periods to add claims under the Defective Premises Act 1972 and the Civil Liability Contribution Act 1978. The Court of Appeal considered appeals both in relation to the preliminary hearing and the amendment appeal. I'm now going to introduce David Sawtell, who is one of our senior juniors specialising in heavy construction and property disputes. He acted as lead counsel for the core participants in the Grenfell Tower inquiry and has acted in many of the cases which have gone to the courts at this early stage arising out of the Building Safety Act, including appearing for the landlord in one of the first final hearings of a remediation order. He also undertakes litigation, arbitration and adjudication, both domestically and internationally, in respect of major energy, PFI and infrastructure works. More importantly, today is his birthday, and David wants to do nothing more than talk about the Building Safety Act today and this important Court of Appeal case. So I'm going to start, David, if I may, by asking you, what was URS's submission in respect of the scope of its duty of care?
Well, Kerry, as you've just explained, by the time that the claim was brought, BDW had sold its proprietary interest in the properties. And when it sold its interest in the properties, there was no physical damage to the blocks in question. No one knew that they had structural design problems. The URS's case was that it owed a duty to BDW to guard against the risk of harm to BDW's proprietary interests and the risk of loss to third parties. So, on URS's case, because BDW had sold those properties, the losses that BDW claimed fell outside the scope of that duty of care.
And David, what did the Court of Appeal say about the scope of URS's duty of care?
Well, to put it shortly, that case was rejected. Lord Justice Colson agreed with Mr. Justice Fraser at first instance, but the law imposed on URS a duty to take care against the risk of economic loss that would be caused by the construction of a structure with a negligent design that, when it was built, would contain structural deficiencies or defects. He looked at a number of URS's supporting submissions, which are useful to consider for those of us dealing with similar claims and defences. First of all, Lord Justice Colson looked at the six-fold checklist set out by the Supreme Court in Manchester Building Society against Grant Thornton UK LLP, a decision of the Supreme Court in 2021. He held that this six-fold test was intended for analysing an alleged duty of care for novel situations, which had not previously been considered by the courts. It wasn't intended to be applied by rote to a well-known duty of care, such as that owed by structural engineers to their employers. He upheld a line of case law that a builder who goes back to rectify defective work can recover the relevant cost, even if they were not under an obligation to carry out those remedial works. So, unlike the way URS had characterised them, this claim for damages wasn't for reputational damages, but were instead conventional claims, such as for the cost of remediation. The absence of a proprietary interest in the buildings by BDW didn't affect the validity of the claim that it was bringing.
Thank you, David. Could I now ask about one of the issues raised by URS, which was when the cause of action occurred? How does that fit into the case and the reasoning of the Court of Appeal?
Well, this goes back to URS's argument that BDW had sold its proprietary interest at a time when no one knew of any problems with these developments. URS argued the cause of action accrued at the time that the claimant came to know of the defect. Their submission was that a building which had suffered a latent defect like this was not enough to constitute an actionable damage in law, so that by the time that BDW had discovered the defects, they no longer had a proprietary interest, and hence there was no cause of action. Well, this submission was rejected by the Court of Appeal, which then made a number of important observations about the accrual of a cause of action in tort.
And I think the obvious question to ask now is what did they say about the accrual of the cause of action in tort?
I think it's quite clear that since Murphy and Brentwood, we now accept about two kinds of loss which are recognised as actionable damage for the tort of negligence, namely physical damage to the property itself and pure economic loss. The leading case on the accrual of cause of action in defective buildings is Pirelli General Cable Works Limited against Oscar Faber and Partners, or the Pirelli case from 1983. That case concerned physical damage to a building that arose from a negligent design. And Lord Scott in Pirelli held that a claimant's cause of action did not accrue until that damage occurred. And Lord Justice Colson acknowledged that it is the law of England and Wales that in a case where there is physical damage, the cause of action accrues when that physical damage occurs, regardless of the claimant's knowledge of it or its discoverability. But in a line of cases after Pirelli, it was held that if there is an inherent design defect which does not cause physical damage, but the design is inherently defective, so there's pure economic loss, like we see in the BDW case, the cause of action accrues on completion of the building. Lord Justice Colson made it absolutely clear. English law has never considered the date of knowledge to be the date of the accrual of the cause of action. So the Latent Damages Act 1986 doesn't change the date upon which the cause of action accrues. It simply increases the time in which you can actually bring the claim. So in a pure economic loss case, such as the BDW case, it was the defective nature of the design which provided the necessary actionable damage, which then completed the cause of action.
David, thank you very much for those interesting insights in relation to that part of the judgment. I'm now going to introduce David Hopkins, who is another of our talented juniors. He practices in construction, commercial, regulatory and public law. A member of 39 Essex's fire law team, he advises clients on duties and liabilities under the Building Safety Act, Fire Safety Order, the building regulations and other legislation, and is currently instructed by the claimant in domestic arbitration proceedings arising from defective cladding and fire collars installed in a large block of flats. He was also instructed as junior counsel for a core participant in the Grenfell Tower inquiry. So David, I'd like to ask you some questions about the Defective Premises Act and first of all ask you who owes a duty under that legislation?
So any person taking on work for or in connection with the provision of a dwelling owes a duty, and that can be a person who's doing work under a contract, or it can be doing a person doing work without any contract, but who is owed payment under a quantum meruit. Could be a person doing work voluntarily, or even the building owner doing work themselves.
Thank you. And could I now ask, to whom is the duty owed, and also what's the scope of that duty?
So the person who's owed the duty is either, if the dwelling is provided to the order of any person, that's section 1A, then to that person, so a person who orders for the provision of the dwelling. And under section 11B, it's to every person who then acquires an interest, whether legal or equitable, in the dwelling. And the scope of the duty is to see that the work which the person doing the work does is done in a workmanlike or professional manner with proper materials, and so that as regards that work, the dwelling will be fit for habitation when completed.
Well, thank you for those introductory comments. And to turn to the URS case, why did the engineer in that case argue that it didn't owe a duty? And what did the court say about the meaning of the words in section 1 of the DPA?
So the engineer's key argument was that as a matter of statutory interpretation, the duty in section 1 didn't extend to the developer. So the developer wasn't owed that duty. The engineer also argued that as the developer itself owed duties under the Act to individual purchasers, it could not be owed a duty. But that argument, in a sense, fell at the first hurdle, the first one, I should say, the statutory interpretation. I gave you basically the words of section 1 earlier, and just to reiterate, it's a person taking on work for in connection with the provision of a dwelling owes a duty to, if the dwelling is provided to the order of any person, to that person. So the court found, and Lord Justice Coulson giving the main judgment, said that the straightforward meaning of those words was that the developer was owed a duty. It was a person who had given orders, that is a contract, to the engineer to provide services for a dwelling or to carry out work to provide a dwelling, and therefore it was owed a duty. There was nothing else in the Act which would negative that.
Thank you. And was it relevant that the engineer was appointed to provide work on a large development rather than a single house?
This is an argument that's come up before, and certainly was one which at one stage I think people thought was potentially arguable. The words of the Act referring to a dwelling rather than, say, a block of flats might suggest that the only connection with single houses, single flats, and so on. That argument had been rejected by Mr. Justice Edward Stewart in Rendlesham Estates. And in the current proceedings in the Court of Appeal, Lord Justice Coulson also rejected the engineer's argument that because it was providing or doing work to provide an entire development, it didn't owe a duty under the Act. Lord Justice Coulson said it should be rejected as a matter of common sense, essentially, and the fact that it may have been providing some work which was for common areas and so on, which couldn't be said to be dwellings in and of themselves, wasn't a reason that its work wasn't in connection with providing dwelling, given that there were many dwellings within each block of flats.
And how about the fact that the developer itself owed duties? Did that mean it could not be owed a duty?
This was an interesting point, I thought. Superficially, one can see the attraction of saying, if a person is owed a duty under an Act, then they cannot also be owed duties under the Act or precisely the same duties by another person. But as construction lawyers, we're all very used to seeing contractual chains, and we're very familiar with knowing that while the main contractor owes duties to their employer, they are also in turn owed duties by their subcontractors. Lord Justice Coulson pointed out that precise analogy and made the analogy with the Defective Premises Act. There was no reason, he said, that a person ought not to be owed duties under the Defective Premises Act and at the same time be someone who was owed duties. Here, the developer owes the duties to onward purchasers of the flats under Section 11B, but is itself owed a duty under Section 11A as a person who's given an order for work in connection with the provision of a dwelling.
Thank you. And what other arguments did the engineer advance in support of its interpretation?
Without meaning to hopefully sound too derogatory towards it, the engineer really did throw the kitchen sink at it and tried his best. So there were various other statutory interpretation arguments put forward. All of those were rejected, but just to run through a few quickly, and I suppose for the benefit of people who might be concerned to run these arguments in future, you're not going to manage to succeed unless you get to the Supreme Court. So the engineer also referred to there being a lack of previous claims by, say, developers against engineers under Section 1 of the Act. The engineer's argument there was that what that meant was claims such as these were inherently unlikely. That was given rather short shrift, and Lord Justice Coulson said that the Defective Premises Act has so far been significantly underused in its lifetime. He also referred to the case of Heron's Court, which the engineer had brought up to make the same argument, or rather in that case, someone had made the same argument concerning statutory inspectors. But I think my personal view on it would be a lack of claim so far isn't in any way relevant to whether a duty is owed, and that certainly seems to be the Court of Appeal's opinion too. The engineer also went to the Law Commission report that had led to the Defective Premises Act. Its argument there was that the report showed the mischief that Section 1 was intended to apply or to cure was problems for individual lay purchasers, so rather than commercial organisations such as the developer. That was again rejected. First of all, it was unclear the report was admissible given the clear language used in the section. And in any event, as counsel for the developer managed to find, there were plenty of references in that report to commercial organisations. The final argument, I think, that was based on statutory interpretation was from the engineer was that Section 6(3) of the Act makes void any term purporting to exclude the operation of the Defective Premises Act. Here, the argument was a little bit more nuanced, or at least maybe complex is the way of putting it. The point the engineer made here was that in a typical contract by which a developer appoints a professional, there'll be many terms which seek to exclude the professional's liability. And the argument ran thus: Section 6(3) makes void any term purporting to exclude the operation of the DPA. And so if the court finds an engineer or professional owes duties to the developers under the Defective Premises Act, then all of those terms that you typically find in a contract appointing a professional which purport to exclude liability would be rendered void. Ultimately, however, the court said that was irrelevant, and I think that has to be right. Just because lots of terms of a contract might be rendered void, that doesn't mean the Act says something different to what it says. And in any event, Lord Justice Coulson was rather sceptical of whether Section 6(3) really had such a draconian effect. So all of those other statutory interpretation arguments also fell, and the court found that going back to the start, the plain meaning of the words was that the developer was owed a duty, since it was a person who had ordered for work to be done for the dwelling.
Thank you, David. And so once it was clear that the engineer owed a duty to the developer, did the engineer have any other arguments why it couldn't be liable?
So the other argument that the engineer raised was that as the developer had sold on the units in the development at completion, it suffered no loss. The developer suffered no loss. Again, I think there's a superficial attraction to that argument, and I can see why it may well indeed be a client here, say the engineers, the first port of call would be to say, well, hang on, they've sold the buildings. How can they have suffered a loss? But once it has been established that a duty is owed to the developer, and knowing that the developer itself also owes duties, I think that argument rather falls away. The developer sold the buildings, but it will still be liable to purchasers under the Defective Premises Act. So anyone who's bought the units from the developer can make a claim under the DPA. And going back to that contractual chain type argument, it therefore rather makes sense that if the developer itself is going to have to be liable, or is liable, sorry, to individual purchasers, it ought to be able to recover from the person who caused the loss in the first place. And the court also referred to its own earlier decision in Bayumi, that's 1997 PNLR 189. And that case had emphasised that the short title of the Defective Premises Act was to impose duties and amend the law as to a liability for injury or damage caused to persons through defects in the state of premises, without making any reference to there being a requirement of ownership. So there is nothing in the DPA which shows that you must have an interest. And looking at the language closely in Section 1, between 1A and 1B, there is quite clearly a distinction being made that any subsequent people who acquire an interest are also owed a duty. And that isn't a requirement in Section 1(1)A, which was the relevant part of the Act that the developer was relying on. So since the developer has suffered a loss in that it is going to be liable to those individual purchasers, the fact that it sold the buildings at completion is neither here nor there, really.
Thank you, David. And so in conclusion, what would you say are the overall takeaways for construction clients?
I'd say most obviously, the decision confirms that the door is open, wide open to developers to use the Defective Premises Act to bring claims against contractors or professionals they appointed whose work was substandard. And that may well be of really quite significant interest to developers who built lots of blocks of flats, say, in the first 17 years of this century. A lot, as I'm sure our guests know, a lot of such blocks of flats have subsequently been found post-Grenfell Tower fire to have substandard fire protection features and so on. So the decision certainly confirms that the door's open to those developers to now bring claims against the contractors and professionals who were appointed to build those developments. And the decision is very much in line with the purpose behind the Building Safety Act, which is a sort of polluter pays type principle to try and drive the cost of remediation and fixing these problems onto the people who were responsible.
Thank you.
I was going to say, Kerry, talking of which, I'm going to now ask you some questions about the part of the judgment which dealt with the Contribution Act. And if I could start just simply by asking you, what was the issue before the Court of Appeal on the Contribution Act?
Thank you, David. The issue with regard to contribution was whether the judge had erred in allowing amendments to the claim to add that claim for a contribution in the context where there's no claim that had been made or even intimated by a letter before action by the individual purchasers under the Civil Liability Contribution Act 1978. And the core allegation raised by the appellant was that the claim was therefore premature. It hadn't crystallised at that stage.
And what did the Court of Appeal decide?
The Court of Appeal reached a number of firm conclusions. It concluded, first of all, that there was no limit or restriction on the right of a person to claim a contribution from another person liable in respect to the same damage. And Lord Justice Coulson adopted the analysis of Judge Havery QC in Baker and Davis PLC and Leslie Wilkes Associates, a firm, reported at 2005 EWHC 1179 TCC. And effectively that subsections 2 to 4 of section 1 of the Act were designed to remove restrictions or defences that might otherwise be raised. And importantly, that section 10 of the Limitation Act 1980 was directed towards time limitation. The intention of that legislation was not to narrow the right to contribution. Thirdly, a third-party claim was not a condition precedent to liability under the Act. This requirement was not referred to or identified at all in Section 1, subparagraph 1. And so Lord Justice Coulson was quite clear that the matter was clearly, the conclusions could be reached purely as a matter of statutory construction. And therefore, he said that a cause of action under this legislation occurred when the 3 ingredients in subparagraph 1A of section 1 of the Act were satisfied. First of all, is B liable or could be found liable to A? Is C liable or could be found liable to A? And are there respective liabilities in respect to the same damage suffered by A? So effectively, the position was one that was clear from pure construction principles.
And did anything else reinforce that conclusion?
Yes, the conclusion, although it was one that could be reached on statutory construction principles alone, there were additional factors that were relevant. First of all, the absence in subparagraph 1 of section 1 of language that appeared in section 1 subparagraph 4 in terms of the words any claim made against him. And they would have been included had that been Parliament's intention. Secondly, the reference in subparagraph 6 of paragraph 1 to any liability which has been or could be established. And Lord Justice Coulson considered that strongly suggested that liability to any third party did not have to be established, in fact, prior to the contribution, but was at least potentially something that was notional or theoretical. And all that was required was notional liability. Lord Justice Coulson also considered that there were wider considerations which supported his decision. Firstly, there was no practical reason why B should have to wait for a formal claim from A prior to commencing remedial work in order for them to be able to claim a contribution against C, and considered that that would reward indolence. Furthermore, there was no reason why the case should be different from Baker and Davis, purely because there was no formal settlement agreement as there had been in that case. He also referred to the consent of the purchasers to be decanted because they allowed extensive remedial works and then moved back, all at the expense of the developer, and considered that could be construed as an implied agreement for the works, even if the entirety of their claim were not formalised. Further still, there were no policy reasons advanced why B should await a formal claim from A prior to having a legal right to claim a contribution from C. And as a matter of policy, that would be regressive. In those circumstances, both as a matter of statutory interpretation and as a matter of policy, there was no requirement for a third party to serve a formal claim in order to activate the liability to make a contribution to the respondent. And neither party had identified any binding authority to the contrary, which led to any conclusion that was contrary to that which I've already outlined. Moreover, Section 10 of the Limitation Act 1980 provided a cut-off date for limitation purposes, such that a claim for contribution must be made within 2 years of the date of judgment or arbitral award. And if there were no such proceedings, it runs from the date of final settlement of the claims. But Section 10 did not address when the cause of action for a contribution arose. And the court also rejected an argument that the developer had ceased to be liable to the third parties as a result of subparagraph 2 of Section 1 of the CLCA. It was not engaged because the relevant legislation was the Building Safety Act, which specified the limitation. And so there was no question of the claim being statute barred. In any event, BDW could rely upon the retrospectivity provision at Section 135, subparagraph 3 of the BSA to achieve the same result. The BSA was intended to be retrospective, and so BDW never ceased to be liable to the third parties. And talking about retrospectivity, I think, thank you for your time, David. That leads me to Hannah Fry, who is our final panelist for today. Hannah has got a broad commercial and construction practice. She's regularly instructed by employers and contractors in a range of construction and engineering matters, both as sole and junior counsel. Hannah has appeared, despite the early stage of her career, in the Privy Council and Supreme Court, and her practice incorporates adjudication, domestic and international arbitration, and high court work, including TCC cases, as well as appearances in the lower courts. She's a member of the Fire Law Group and has advised on a number of matters concerning the Building Safety Act, including remediation contribution orders, and is contributing author to the chapter on adjudication in the TCC and Housing Grants, Construction and Regeneration Act 1996 in the recently published The History of the Technology and Construction Court on its 150th anniversary, Rewriting the Rules. And Hannah, thank you very much for dealing with retrospectivity for us. I'd just like to start by asking, by way of recap, what changes does the Building Safety Act make to the limitation period in respect of building defects?
Thank you very much, Kerry, and good morning, everyone. Section 135 of the BSA inserted a new Section 4B into the Limitation Act 1980, providing for a special time limit for certain actions in respect of building defects. In summary, first, if a claimant seeks to bring a claim under Section 1 of the DPA for the provision of a new dwelling, then they will now be able to bring a claim for works that were completed in the 30-year period prior to the 28th of June 2022, when the BSA first came into force. So, for example, this would mean that defective work completed on a building and a new build or converting an office block to residential flats after the 28th of June 1992 could now be the subject of a claim. For Section 1 DPA claims where works were completed after the 28th of June 2022, when the BSA came into force, the limitation period has been extended to 15 years from the date on which the right of action accrued. So 30 years looking backwards, 15 years looking forwards.
Thank you. And what was the position on limitation period for Section 1 DPA claims before the Building Safety Act? And what impact are the changes under that legislation likely to have?
The previous limitation period for Section 1 DPA claims was 6 years. So you can see that this extension of the limitation period introduced by the BSA is significant and far-reaching.
And what's the position regarding claims that were settled or determined in court before the Building Safety Act came into force?
So where there are claims that were settled or determined in court before the BSA, in essence, the BSA doesn't apply to such claims. And this is set out in section 135 sub 6 of the BSA, which provides that nothing in this section applies in relation to a claim which, before this section came into force, was settled by agreement between the parties or finally determined by court or arbitration, whether on the basis of limitation or otherwise.
And to turn to the Court of Appeal case, what was the main issue regarding limitation and retrospectivity in this case?
So the key issue in the URS case was whether the retrospectivity provided by Section 135 of the BSA excluded the rights of parties who were involved in ongoing litigation. So we've seen the position where claims were settled prior to the BSA coming in, but what about parties who were already involved in the process going through the courts? So were they exempt from the otherwise widely worded retrospectivity provision?
And what did the Court of Appeal decide on this key issue?
So the Court of Appeal held that Section 135 of the BSA was retrospective in effect. And although there was this clear exception that we've been through, addressing claims which had been finally determined or settled, expressly provided by Section 135 sub 6, there was no exception relating to the rights of parties involved in ongoing litigation.
And what was the reasoning for that decision?
So the reasoning was really twofold. First, the ordinary linguistic meaning of the words used in Section 135 sub 3. The amendment, which by way of Section 135 of the BSA adds the extension to the relevant limitation position, is to be treated as always having been in force. And it was those express words which led to the Court of Appeal's finding. The second main factor was the fact there was an express carve out for parties whose claims under the DPA had been finally determined or settled, suggested that Parliament had turned its attention to the wide words used in Section 135 sub 3 and decided that there would only be one exception as expressly provided for in subsection 6. And if Parliament had intended to carve out to protect the position of parties in ongoing litigation, not only would they have said so, but such provision would have been relatively easy to provide for expressly in the legislation itself. Further, a carve out for parties in current litigation whose rights have not been finally determined or settled would be unusual generally. The Court of Appeal were not taken to any other legislation which had the same or a similar exception, and it would be difficult to justify on policy grounds.
Thank you very much. And what are the effects and all the likely impact of the decision?
I think the key takeaway in terms of retrospectivity is that parties involved in ongoing litigation will be able to take advantage of the extended limitation periods provided for by the BSA. The clear exception as provided in the legislation is that parties involved in claims which have been finally determined or settled will not be able to benefit from such extended limitation periods. Therefore, whilst we already knew that the extension of the limitation period provided for in the BSA is significant and far-reaching, this URS decision confirms that it's perhaps even more further-reaching than we first thought. So it's expected that we will see an increase in parties in ongoing litigation applying to amend their pleadings, as in the URS case, to include DPA claims where the extended limitation period provided for by the BSA applies and allows them to do so. So legal representatives should be checking whether this is applicable in their ongoing cases before the courts. So one could say that the floodgates have been pushed open just a little bit more.
Hannah, thank you very much. Now, untypically for barristers, we seem to have finished in good time. So I'm actually going to open the discussion up for some questions. Now, one of the questions we've received, unsurprisingly, is whether there are any proposals to appeal this decision or to seek permission to appeal. I'm not aware of any. Do any of the other panel members want to jump in and raise any comments on that?
I can't see any pending applications for permission to appeal. What I'd say is Lord Justice Colson has dealt with his matters in a relatively vanilla way. I am unsurprised by the outcome, but what the judgment does provide is possibly some comfort for future appeals rising out of different issues. So, for example, the date of accrual of a cause of action for pure economic loss, I said that was dealt with by Pirelli, but Pirelli was a case involving physical damage, didn't deal with pure economic loss because we didn't know we could recover pure economic loss against professional until Murphy and Brentwood, and was decided on the assumption that any time you have a negligent design, it's always going to end up in physical damage. So Colson's comments would probably give comfort to someone applying for permission to appeal if you're arguing about the accrual of a cause of action in respect of negligent design but hasn't yet manifested itself in physical damage. Yes.
Thank you, David. We've got some other questions. And one of them is, does an engineer or other consultant, subcontractor owe the same duty to a contractor? Does anyone want to leap in on that one?
I mean, I already volunteered beforehand to answer this, so I'm going to put my hand up again, Kerry, I'm afraid. It's a different form of duty of care. What we've been considering, we might call our emanations of a Donahue and Stevenson type of duty of care for damage to a building, like you see in Murphy and Brentwood and Merton. When you're looking at duties owed between participants in a construction project, you're normally looking at a Headley, Byrne and Heller style assumption of responsibility. And the courts have historically been very, very reluctant to allow parties to jump over the contractual allocation of responsibility, to try and find duties of care when actually they owe their duties to their contracting party and to their client, and jump over contractual processes to reopen certificates such as for adjudication, arbitration, or simply go to litigation. But I note when parties have applied to strike out claims on the basis there's no duty of care, there was a case in front of Mrs. Justice Joanna Smith last year, Advantage against GB Building Solutions. The TCC refused to strike out on the basis there was no duty of care. So it's not a case of never or a case of it's going to be struck out, but it is a case of it's going to be very difficult.
Thank you. Please do jump in again if you feel the urge at the next question. Next question is, what happens if a developer is successful in bringing a claim against an engineer, but a purchaser of dwelling subsequently wishes to bring a claim against the engineer, but the developer's taken the money and run and has not fixed the defects? Does anyone want to?
I'll volunteer an answer on that, which I'm going to say is merely provisional, but it seems to me a individual purchaser in that situation does have a good claim against the engineer. The engineer owes a duty to that person under section 11B. It also owed the duty to the developer, and the developer maybe had a successful claim against the engineer in the past. But in our scenario, it sounds like the developer is rather unscrupulous and has done a runner. The individual purchaser, I think, still has a good claim against the engineer, and the engineer would then have to claim over against the developer. The building, the developer would obviously be liable to the engineer for the same loss, so it would have a good claim, the engineer that is, in Contribution Act.
Yes.
The way it was actually dealt with in Vendlesham Estates, which is a claim under the Defective Premises Act, was to actually order the money to be paid to the management company effectively held in escrow, so be paid for remediation. So the TCC is fairly alive to the fact people could be doing runners. I mean, BDW isn't that case because they'd actually carried out remediation. BDW.
Yes. Thank you very much, both of you. I'm also asked, would anyone like to comment on what constitutes unfit for habitation under the DPA? Anyone want to jump in on that?
I'm happy to. Since it's my birthday, can have another gift. In that, Rendlesham Estates provides a really good summary of the law on fitness for habitation. So it's quite clear on the state of the law at the moment that minor disconformities, but minor points, trivial breaches do not constitute fitness for habitation. Although the line of case law was actually criticised by Mr. Justice Ramsey in one of the cases on the Defective Premises Act. You're looking at whether it's beyond merely temporary, you're looking at whether it causes discomfort and whether it causes effectively risk to life as well. But I say Rendlesham Estates is now treated as the leading authority on that multifactorial test as to whether or not something is fit for habitation.
Was a point raised, I think, in this case, in URS and BDW, about the fact that in Rendlesham Estates, I think the part of the unfitness for habitation was defective shower trays, and that might sound fairly minor, but I think, as one of the other judges in the Court of Appeal pointed out, if you can't wash effectively in your house, then it's not really fit for habitation. So there have certainly been in the past, I think it's probably fair to say, people seeking to put a very high bar on what unfit for habitation means. But it's while it's not trivial minor problems, it isn't necessarily a sort of Victorian hovel or something that you need to show before you can say a building is unfit for habitation.
I entirely agree, David. I've certainly had cases involving arguments of that type, and the courts are very alive to avoiding that kind of exclusion approach. Another question we've had is could the argument be raised for defending a retrospective 30-year claim as being contrary to Human Rights Act right to fair trial due to passage of time, destruction of documents, etc.?
I'm happy to take that one. So we've now got a retrospectivity question. This was something that was raised in the URS decision, and particularly if you look at the sections of the judgment that are dealing with that. In particular, if you look in the decision at it's paragraph 170 that they specifically deal with whether there is a Convention right or Human Rights Act clash. And here they said that there was no clash with the Article 6 Convention rights, because they're expressly preserved by section 135 sub 5. But they've said, for example, if URS could show that in 2016 they had destroyed some critical documents which might have provided a defence to the claim under the DPA, because they assume that under the existing law any relevant claims were statute barred, then they may be able to deploy that fact at trial pursuant to section 135 sub 5. But that possibility has no effect on the clear intention of Parliament to make the BSA retrospective without any qualification relating to ongoing proceedings. So I think it's very fact specific, and that's dealt with specifically in the judgment. And as I say, it's 170, paragraph 170 onwards.
I think that one's quite an interesting one, because it does seem to me that that's going to be quite a time-specific issue. So I think factually, someone who happens to have had documents destroyed prior to anyone knowing about the Building Safety Act will perhaps be in a better position than someone who decides to employ mass shredding at this stage in the full knowledge that that's the position. But I can see some interesting arguments and appropriate cases on that kind of issue. We've had some further questions. If there's a forward funder purchaser who's entered into a development and funding agreement with a developer, a common development structure to carry out a development, are they likely to owe duty to the developer as well as being owed a duty? Anyone want to jump in on that one?
think I would have to say I'm not sure I fully understood the question, if I'm completely honest. That might be one to take up with the questioner, possibly post, for me at least. I'd want to spend some time thinking about it before I really gave a solid answer on that one.
Well, I think that's probably, you know, we do invite anyone who sent in these questions to follow them up with more detail by email, because sometimes they're the really interesting questions that require some proper thought and reasoning. I think we're reaching the point now where we've probably dealt with most of the questions. If anyone else does want to email us, please do. And I'll just repeat what I said at the start of the session, which is we have the article on the website. Please do go to the website to look at that. And also, please do feel free to email any of us individually or collectively to get our thoughts on any further matters. So thank you very much to David, Hannah, and thank you. Sorry, I sort of slightly trailed off there. Thank you, everyone.
Thanks. And as Kerry says, please do email us on the emails you can see there if you've got further questions, and we'd be delighted to assist.